You use your computer program, or a system that you have to create a creative work. Can you get copyright protection in that work? I'm Mike Steger. I'm a copyright and trademark lawyer. And today I'm going to discuss the requirements for authorship regarding artificially generated creative works. So the copyright compendium, which is essentially the manual that the Copyright Office uses to evaluate copyright applications. For a long time, it is said that materials produced solely by nature, by plants, or by animals are not copyrightable. And what courts and the Copyright Office have interpreted that to mean is that the authorship requirement for copyright can only be fulfilled by a human being. So, if something just grows in your garden, if you put two plants together and they create a new plant, you can't get copyright protection in that new plant because that's created by the plants interacting. There was a case that PETA brought a couple years ago where a nature photographer had set up an automatic camera out in a forest, and when the animals, walked by the sensor, they triggered the camera to go off and create the photographs. And PETA's argument was that the animals were actually the authors of the photographs and that they would own the copyright. And the court struck that down, saying they're animals, they're not humans, they can't be the author. A couple years ago, a gentleman filed a copyright application for a work of art that was created by an AI program that he developed, but it was purely created by the AI program. Copyright Office rejected his application, and then earlier this year, on a second request for reconsideration, Copyright Office rejected his application again because there was no human authorship of the work. It was completely created by the computer program. The individual who submitted the copyright application argued that this human authorship requirement is unconstitutional and it's not grounded in law. The Copyright Office rejected that argument. And he also tried to argue that the AI program could be the author under copyright law because it was a work for hire, because he actually owned the AI program. But the Copyright Office rejected that because it found that the AI program cannot legally enter into a contract. And one of the requirements for work for hire is you have to have a legally binding contract. And as lawyers know, a computer program cannot legally enter into a contract, does not have the authority. So this is a little bit obscure, but in the world of NFTs and artificial intelligence and having computers create a lot of stuff, thought you might be interested. If you have any questions about any copyrighted work, whether it's created by a computer or created by you, give me a call. I'm Mike Steger. I'm a copyright and trademark attorney.